Hi, this is Patrick Conroy, and we're doing Chapter 9, Motions Practice. So, what is a motion? Let's begin there. Anytime you're asking the court to do something, that's considered a motion. And they come up in various formats all through the process. Just the generic term is motion. So the learning objectives are prepare a motion in proper format, explain how lawyers may use motions during the pleading phase of a case, and explain how lawyers may use motions to compel opponents to comply with rules of court and evidence. Describe the use of motions to terminate a case before trial. Explain how motions can be used at the end of a trial. See, lots and lots of types of motions come up all through the whole case. Okay, a motion is a formal request to the court seeking some type of relief during the course of the litigation. Motions seek relief from certain actions or inactions that arise during the process of the litigation itself. Forms of motion typically follow the same form as pleadings, must be served on all parties, and federals require a notice of motion to accompany the motion. So you make a motion to the court, there should also be a notice of a motion to the other side that you've made this motion. Okay. Types of pleading phase motions. This is before the trial, and you've gotten the original service of the pleadings. Now, what you might do is file a motion to enlarge time to respond. You might only have 30 days. You'd be like, wait a minute, I'm going to need more time to respond to this. So it's a request of the court allowing additional time to respond to a pleading, especially an answer. This is very, very common. Sometimes it's even handled by a phone call to the other side saying, hey, I'm working on a big case right now. Can we push this back 60 days? And if you say no, they will remember you said no. So when you call them to ask for more time, they're going to say no. So you have to go to court. Motion for default judgment. Okay, this is a judgment by the plaintiff against the defendant where the defendant has failed to respond in a timely fashion to the complaint. You issued the complaint, they have 30 days to respond, they didn't. So you might make a motion for default judgment. Now, even if you win, there's a chance that they can come back and say, hey, sorry that we weren't able to answer on time. This was the issue that we were dealing with. And if it's something legitimate, the court will say, okay, we'll give you more time. But you should also have your answer there when you do the motion, responding to a default judgment. Rule 12b motions, defenses to the complaint that must be included in the defendant's answer and ask the court to dismiss the complaint. Okay, so this is when they've done the pleadings. You as the defense are responding, and your motion might be, hey, dismiss this complaint. There's no cause of action here. Other types of motions are, hey, this court lacks subject matter jurisdiction or personal jurisdiction, or this is, not the proper venue. There's something faulty in the process. Failure to state a claim upon which relief can be granted, and failure to join an indispensable party. Now, most of these motions can be corrected through another motion, of course. Motion for judgment on the pleadings. This is, a defense's answer, and they say, hey, even if everything they say in their pleadings are correct, there's no judgment here. Or it could be that there are no disputed material facts, and just apply the law, and you'll see that the plaintiff is entitled to judgment. Now, they also can use motions to compel opponents to comply with rules of court and evidence. So, a motion to compel. motion seeking the opposing party's cooperation and compliance in responding to discovery requests. So this is when they are not cooperating with discovery. You can file a motion to get the court involved so they behave. If they continue, you can make a motion for sanctions. Where order compelling a party to cooperate is not complied with, the next step is to request the court impose a penalty against the non-compliant party until they start helping with discovery. Now, you can do a motion for protective order saying, hey, some of this information must be disclosed or must not be disclosed. It's a trade secret. We can't let this get out. So we have a motion for protective order. Motion for summary judgment. That's when the party says, hey, there are no disputed material facts, and all that remains is the application of the law to the facts. So the defense would say, hey, there's no cause of action. The plaintiff would say, it's clear, even they agree to the facts, we just need a judgment. Motion in limine. Courts require pretrial motions or motions in limine prior to trial to streamline the operation of the trial itself. These are areas of agreement and disagreement with the judge ruling on the disputed matter, such as evidence being admissible. So this is just to make the whole time in court shorter. If you both agree to something, why put on evidence about that? Explain how motions may be used at the end of a trial. Okay, this is when the verdict comes back from the jury and it makes no sense. So you can say, judgment notwithstanding the verdict, they ask for the judge to issue the verdict even though the jury came back with one, because what the jury came back with is not allowed in law. Judges are usually pretty hesitant to do this. They would rather, go to appeal than for them to say to their jury, hey, y'all were wrong, I'm going to fix this. It really pisses juries off. And remember, most judges are elected at the state level. Okay, this might be, the jury verdict comes in, and it might be you might be in a jurisdiction of comparative negligence, where in comparative negligence, say you are 70% at fault, but the plaintiff was 30% at fault, then the amount of the verdict that they get is only 70%. So that's one reason why you might need to mold the verdict. Motion for a new trial. This is a request for a new trial, a whole start over because an error was made in the trial by the judge or jury. So this is after the trial, and this is not an appeal where you can only, do certain things. It's a request for a whole new trial. Okay, that's it for this presentation. Good luck. I've posted some really good videos for this, and it'll really help sink in the information for you.